All right, good morning, everyone. Thanks for joining us. This is Kirsten from COVA, and I'm joined by Amanda Gall from the Colorado District Attorney's Council. Just one quick announcement. If you are planning on using this webinar for COVA Victim Advocate Certification, you should receive an email after the webinar from me as your proof of attendance. If you don't receive that email, go ahead and reach out to me, Kirsten at COVA at 720-399-8281, or reach me by email. If you're watching this archived on YouTube, we're glad that you have joined and hope that you find it useful. Archived webinars cannot be used towards COVA Victim Advocacy Certification. If you haven't used GoToWebinar before, you'll see there's a function with there's a chat or a question box and also a raise hand function. We'll be monitoring that. So please jump in with any questions that you have at any time. Your question will not be, you won't be identified as the person asking the question. We'll just ask and answer them. And with that, we'll hear from Amanda. Thank you.
Good morning. Thank you to everyone for joining us. As Kirsten said, my name is Amanda Gall, and I work for the Colorado District Attorney's Council. I am the Sexual Assault Resource Prosecutor for the Council, which means essentially that I represent the state's 22 elected district attorneys in their sexual assault policy and litigation positions, and then also help do some training for the state's prosecutors and sometimes still try cases. Prior to that, I was a Special Victims Unit prosecutor in Jefferson and Gilpin counties. So this morning I wanted to chat with you all and demystify a little bit Colorado's indeterminate sentencing scheme for sex offenders. This can be a little bit of a complicated area to understand. I certainly want to encourage you to interrupt the drone of my voice with asking questions. Kirsten will ask those for you so that we can make sure that everybody really has a good handle on what indeterminate sentencing is when we've finished our time together today. So I'm going to start by placing indeterminate sentencing slightly in a bit of a larger context for you. And as you all are probably familiar coming with your association or however you came to COVA, sexual assault is a rampant offense in our society. If you look at the most recent research on incident rates in terms of the number of adult women, the number of adult men, and the number of children reporting that they've suffered some type of sexual abuse, and you take those statistics and you extrapolate them essentially into the Colorado population, so the last population census level statistics, you see what is the largest blue triangle there on this path to prison slide. And I wanted to place that in context because you look at those numbers and they're really shocking. There are hundreds of thousands of Colorado women, men, and children that have suffered some type of sexual abuse. But when we think about the number of abusers that are in our communities, very few of them make it down this triangle funnel to actually end up in some type of incarceration situation. So if you look at that large blue incidence rate triangle that has those statistics and numbers about Colorado women, men, and children, the next smallest piece of that funnel, which is a pretty significant drop-off, are the number, depending on population, of those crimes, of those incidents of sexual abuse that get reported to law enforcement. And then even fewer of those are in that next pink stripe that get filed, and then even fewer of those result in some type of convictions. And then you can hardly see that little tiny black dot down at the bottom of that triangle that it represents folks that actually end up in Colorado in a prison environment. Because even after we get through the process, perhaps a victim or survivor testifies at trial, or perhaps there's a plea bargain that results in a conviction for a sexual offense, most offenders in Colorado are initially sentenced at least to a community-based sentence and don't suffer any sort of incarceration sentence at all. So I wanted to give that kind of overview so that when we talk about who is subject to indeterminate sentencing, you just realize that it's a very small number of folks when you think about the number of folks that are actually out in the community. We have about 21,000, give or take, registered sex offenders in Colorado, and only a very small portion of those will ever have been incarcerated or will ever have been convicted of an indeterminate sex offense as opposed to some other type of sex offense. So let's take a look at those. Colorado divides its sex offenses in a couple of ways. So one way that we look at sex offenses is certainly by class of offense. Colorado has two general types of offenses. We have felonies and we have misdemeanors. At the felony level, there are class 1 through 6, with 1 being the most serious felony offenses, and then we have misdemeanor, which are subject only to county jail or probation. So when we look at felony level sexual offenses, there are two types. There are those that are subject to indeterminate sentencing and those that aren't. So one thing to remember as you're thinking about that pyramid of folks who ultimately get convicted of some type of sexual abuse in Colorado, even a smaller set of those have committed what we refer to as an indeterminate offense. And so you can see those here on your screen. The first one, the first few really can be committed against either children or adults. Sexual assault is, what folks traditionally in the community think of as rape, and that can include offenses that are certainly non-consensual. It can include offenses committed by force. It can include offenses that are against children with a certain amount of age difference. There's a lot of different ways in Colorado, or by drugging, for example, drug or alcohol facilitated sexual assault that fall under that first one. The second one is a felony level unlawful sexual contact. That's where some type of sexual contact is made without consent. There are a couple other ways that can be committed. That's usually a misdemeanor, but can be a felony if it's committed by force. Then we have sexual assault by a peace officer or by a psychotherapist. Those are unique crimes that are based on the theory that those persons, peace officers, police officers, and psychotherapists have special influence or special power over their victim, and so there's a specific crime for that. And then we have the crimes that relate to children, so sex assault on a child, sex assault on a child by someone in a position of trust who's a teacher or a coach, enticement of a child for sexual purposes, incest, patronizing a prostituted child, luring someone on the internet, luring a child on the internet, or sexually exploiting a child on the internet. So how indeterminate sentencing is designed to work is really the concept is, hey, we acknowledge as a community, both based in the research that's been done on the population of sex offenders and just general experience with that population, that there are some sex offenders for whom treatment and intervention will work. Based on their individualized circumstances, they either are responsive to treatment, they're willing to engage in treatment. What we know about treating them might have some effect on whether they will go on to reoffend if they're allowed to either remain or to return to the community. At the other end of the spectrum, there are offenders for whom it won't work, that no amount of intervention, no amount of supervision, no amount of anything that we have the capacity to do in terms of an intervention with that offender will stop them from reoffending. And so we have to decide, who is that? How do we tell when we encounter an individual offender in the criminal justice system where they fall on that spectrum? And indeterminate sentencing is essentially intended to account for that. And what it says is, we will either give you a minimum time on supervision in the community if you're sentenced to probation, or in prison if you're sentenced to prison, and then we require you to complete treatment and be under the best type of supervision and intervention that we are capable of providing and know how to do, and it's constantly improving. And it's up to you to reduce your risk to reoffend in terms of the offender. It's up to that offender to reduce their risk to reoffend and demonstrate that they can be returned to the community. And if that never happens, then it's a life sentence. So how that works in practice is, depending on the level of offense, you see on the slide, you have a Class 2 felony, Class 3 felony, Class 4 felony. Depending on how that works, the judge will pick a bottom number in these ranges. So for an F2, it's 8 to 24, for example. So the judge can pick any number between 8 to 24, and then the sentence will be up to the rest of their natural life. So if you go to prison, for example, for sex assault of a child, that's class 4 felony. It can be 2 to 6 to life. And the judge sentences you to 2 to life. The way it's intended to work is that you can, if you are willing to discuss your offending behavior, if you are willing to participate in treatment, if you're willing to do sort of the hard work that that requires, you can be out in 2, or you can be out never if we figure out that you're someone for whom that won't work. And that's the balance that indeterminate sentencing tries to strike. The one thing that I know to put on the bottom of this, it's especially important and especially difficult when you're talking to victims and survivors, for district attorneys, for advocates, for everyone that's involved in the system, is we don't really have what we call certainty in sentencing, or maybe you've heard of it as truth in sentencing in Colorado. So 2 doesn't really mean 2, and 4 doesn't really mean 4. And whatever the bottom number is, isn't that number. And that's also true for determinate offenses. So if you think about the other class of sex offenses that are not indeterminate, so child pornography, for example, if you distribute child pornography, you're just going to get a sentence. It'll be 10 years. It could be, you know, whatever the sentence is, whatever the number the judge sentences you to, is not when you're going to be actually eligible for parole. So I've provided a chart on the bottom there to give you an idea of, you know, and sometimes it varies a little bit by sex offense, but when a person becomes actually eligible to be paroled, which is going to be sooner than that minimum bottom number or that determinate number, depending on the offense that the judge imposes, and even sooner than that will be eligibility for you to transition to a community corrections or halfway house type environment. So it's difficult when you're talking to victims and survivors about what a plea might mean or what a sentence actually means, because parole eligibility dates are confusing. They are moving targets. But as you'll see when we get to when folks are getting out, you know, it can be less than the minimum sentence. So I just wanted to make sure you understood that. All right. So when and how do you get out? The way that it's designed to work is you were supposed to get out if you're supposed to get out, when you have successfully progressed in treatment such that you do not pose an undue threat to the community to reoffend. So you have to engage in treatment and you have to participate in what the treatment team's assessments of you in determining when you would not pose an undue threat to the community. If you're in prison, that's when you meet these criteria, that's when you can go before the parole board, assuming you're parole eligible, based on that date we just discussed. And the parole board can decide based on a number of factors whether to release you. If you're on probation, there's similar criteria that determines when a court can decide to terminate your probation, terminate your supervision. So basically, there are 2 types of criteria. One is in the statute, and one is criteria that's set by the Sex Offender Management Board, which is a statutory board created by statute. I'm a member of it, but that has various stakeholders: defense attorneys, prosecutors, treatment providers, folks that evaluate risk, judges, victim advocates that get together and create standards for the management of sex offenders in prisons in the community. And they have some additional criteria that involve taking responsibility for the crime, that you have an adequate parole plan when you're released, that you're giving truthful, complete answers, and most critically that you have victim input. So you can see there that you also have to meet those criteria in order to be eligible for release. So that's how the indeterminate sentencing system is supposed to work by design. In general, I thought you might enjoy some just general statistics. There's a couple of ways you can arrive at either an indeterminate sentence or a determinate sentence in Colorado. I put that funnel that we talked about at the beginning on the top right here because I still want to remind you that we're talking about folks who've been reported to law enforcement, investigated, where law enforcement has determined there's enough evidence to present that to a prosecutor, where a prosecutor has decided to file that based on the standards that they're required to uphold, and then you get all the way through the court process to a conviction. And so we're talking about a relatively small pool of offenders based on how much sexual abuse we know is happening in the community. So we took a look at, for a few-year time span, of every case that began with an indeterminate sex offense, where the prosecutor charged one of that list of indeterminate sex offenses, so sexual assault on a child, those charges that we went over in the previous slide. In 84% of those cases over that 4-year period, it resulted in some type of plea bargain. Certainly there are many reasons why a case might be plea bargained. There are lots of factors that go into that. Victim input and survivor input is a huge part of that. You know, whether and how the trial process might re-traumatize them, whether a plea bargain, of course, can result in something that appears to resemble some sense of justice for that victim or survivor, community safety. Oftentimes we're also looking at evaluations of a particular offender's risk. And for me personally, not every prosecutor approaches it this way, but for me personally, I don't plea bargain a case unless someone is admitting their sexually abusive behavior. To me, if someone is not taking accountability for their sexually abusive behavior, they're unlikely to succeed in treatment. They are unlikely to do the difficult work that might reduce their risk to reoffend. And I think it's important, at least anecdotally, to the victims and survivors I've spoken to. And so that's just one approach, but there are many factors that go into that. 16% resulted in trial. When we went to trial in Colorado, we convicted 60% of the time, which, if you're aware of the national statistics, is a really good number. You know, certainly it's still not 100%, which would be great, but knowing what we know about the myths surrounding rape culture, the biases that juries bring to these cases, Colorado trials, prosecutors, investigators were doing better than average by a fair bit. What's really important, I think, for those talking to victims and survivors in the community is sentencing. Whether we went to trial, although certainly prison was a more common outcome after a trial where a judge has heard in significant detail all of the various circumstances of the sexual abuse and the conduct, and certainly from the victim who had to testify. But regardless of whether you're looking at trial or combining trial and plea, 70% of offenders in Colorado, even when we get all the way through that funnel to that next to last stripe to conviction, are sentenced to a community-based sentence. That might surprise folks in the community when you look at some of the cases where there's been outrage, justifiable outrage at the outcomes around the country. Those would not be uncommon here in Colorado. Most offenders, and these, remember, started as indeterminate offenses, so that's not even including in these numbers the offenses that started as determinate, which are often seen, though they can be equally as traumatic, but are often seen by those in the legal community as sort of the less serious sexual assaults, even though we know that that's not really true in terms of victim impact. But you see that most folks are getting probation, and most folks are or community corrections or some sort of combination of that. So even when you're getting all the way through this funnel, you are most likely remaining in the community in Colorado. So to place that in even more context for you, most offenders who have been convicted of a sex offense in Colorado and who are on the sex offender registry have completed their sentences. They're not under any type of supervision. So we've gotten them through that funnel, we've treated and intervened, and they are, or in some cases we haven't, because they've just killed their number in DOC, but we'll get to that. They are in the community completely unsupervised. They're just on the registry. 3,800, and these numbers, of course, are moving targets, depending on when you pull the snapshot on probation and parole, and then the number in prison has upticked slightly. It's about 5,000, give or take, which represents 25% of the prison population in Colorado. So a quarter of the folks in prison in Colorado are sex offenders, even when you consider how hard it was to get them there. So we took a look at, we thought one of the best ways to look at indeterminate sentencing and how it's working and what's happening to these folks, certainly it can be improved, but was to look at the number of folks who've been there. The indeterminate sentencing was imposed by the Colorado Lifetime Supervision Act in 1998, and the first offender that was convicted under the Lifetime Supervision Act was sentenced in 2000. And so we have about 18 years of data. We'll have another year of data coming up here when the Sex Offender Management Board releases their Lifetime Supervision Report in November, so we'll be able to update these numbers. But in 20 years, essentially, 2,700, about 2,800 offenders have made it to prison. One thing I want you to really understand that's really important context for this conversation is not all of those offenders were part of that 30% that were directly sentenced to prison. In fact, most of those offenders started on a community-based probation sentence, and they violated their probation to the extent that they were finally resentenced to prison. Sometimes we often hear about or there are rumors or whatever the case may be that, oh, these folks, they mess up one time on probation, they're being sentenced to prison. That's not true. Or they're committing technical violations. Well, the definition of a technical violation is anything that's not a new crime. It can, or that's not charged as a new crime, even if it is a new crime. It can mean contact with a victim when they're not supposed to. It can mean contact with children. It can mean relapse into substance abuse, which is particularly concerning if substance abuse is a factor in their sexually offending behavior. It's really every single, it can be viewing child pornography. It's every single thing that's not charged for whatever reason as a new offense is a technical violation. When we looked at that 4 years of data, and we looked at the folks who were initially sentenced to probation to the community, it took an average of 3 times for them to be subject to revocation before they finally ended up in prison. So what that looks like in practice is a probation officer who certainly they don't revoke by practice on the very first technical violation, of course, but they reach a critical mass of violations or a very serious violation and they file a motion with the court to revoke. The prosecutor goes through a hearing potentially, or the offender admits that they violated probation. And oftentimes, after that process, when it comes to resentencing that offender, the judge will simply reinstate probation. And it took an average of that process happening 3 times for somebody to finally get sentenced to prison. And so I say that to say, when you're considering who's going to prison, in the indeterminate population, you really are talking about folks mostly who've earned their way to prison, either because they've failed multiple times in the community or because their initial crime was so heinous that the judge, after hearing the facts and hearing from the victim or survivor or victims and survivors, decided that they were part of that 30% that were going straight to prison to begin with. So that's who this population is. They committed among themselves 5,800 indeterminate offenses. That's not including other offenses. They certainly committed some other offenses, so say if you had a robbery associated with it. But they committed, 5,800 indeterminate individual convictions.
Can I ask a question?
Certainly.
So when we talked about technical probation violations, in your experience, like viewing child pornography, which is its own standalone crime,
Sure.
would that be one where probably it would just take one offense to get a revocation filed and for that person to go on to DOC, or have you seen it go either way there?
It's really interesting that you asked that, Kirsten. Child pornography is sort of a unique offense because in my anecdotal experience, of course, I'm not speaking, for every courtroom or judge, often what you will get from a defense attorney at resentencing, because of course both sides get the opportunity to speak, the victim or survivor gets the opportunity to speak about what should happen to an offender who has violated probation. Oftentimes you will hear the argument from a defense attorney and sometimes from the courts themselves that child pornography is some type of lesser offense because it's not a hands-on offense by this particular offender. Of course, we know that in the research, the vast majority by self-admission, I think it was 56% of child pornography possessors had committed a hands-on offense. But you will often get folks who take that slightly less seriously. And sometimes there will be a decision if somebody's doing mostly while in treatment, not to charge a new offense. You know, I think there's a great understanding in Colorado. Colorado is quite progressive in wanting to treat and intervene everyone that's amenable to that, everybody for whom you can do that in order to prevent future victimization, which is entirely appropriate. But it's a process. If you think of, you know, certainly sex offending is not like addiction, so it's a terrible analogy, but if you think of other types of issues that you're treating, it's going to be, you know, 2 steps forward, 1 step back. And so oftentimes you will see a district attorney elect not to file a new charge depending on the treatment team's discussion of that offender. But I don't think there's any one circumstance, because judges are so individual, cases are so individual, that gets someone a straight ticket to prison.
So I actually can just see the questions on this computer.
You good? Oh yeah, sure. Yeah,
so,
no.
We're going to pop over for a second.
Maybe we'll pause and take, oh, I don't see. Okay, perfect. Just making sure we didn't miss anyone. So these folks, so these are the folks, when you think about that, you know, what a little less than 3,000 folks have ever made it to prison, either because they earned their way, you know, one way or the other, on an indeterminate or quote unquote lifetime offense. That's a drop in the bucket. Of what we know about the true amount of offense, or just in general in terms of how many offenders we know are convicted generally. So what kinds of crimes did they commit? Who's ending up in prison? You can see here that the vast majority of folks are there on a charge of sexual assault on a child. Certainly they're there on sexual assault too, which can be an adult or a child. You can see the numbers as they drop off. Only one person has ever gone for sexual assault by a psychotherapist. Not sure what that case was about. Yeah, I guess that's good for that profession. But most folks are there for crimes against children. Which can be looked at, you know, certainly a couple of different ways depending on your perspective. I think sometimes courts take offenses against children more seriously, which certainly, you know, shouldn't be the case. They are very serious offenses, but certainly trauma to adults is very serious as well. But most offenders that end up in prison are there for offenses against children. You know, so we look at the cases where we know they were children, and that's 75%. Another 2% were incest, which were probably children, just based on the way those cases come to us. We don't get very many cases of adult incest, brother-sister adult relationships, although certainly that's possible. And then certainly the age not specified. If I give you an example of a child who's incapacitated, for example, when they're assaulted, that's a higher class of crime than sexual assault on a child. And so that may be the crime that the district attorney elected to proceed on or to plead to. And so just because the age not specified isn't specified in that 23% based on the crime of conviction doesn't mean that those aren't also potentially children as well. We often hear too, you know, oh, they get older, offenders get older, and then they just stop offending. It's like they age out of it. You know, there's certainly a drop-off, but, you know, if you see all the way on the right of the slide, there's an 84-year-old. I double-checked to make sure that was accurate. But here's the age distribution. This, again, this is just the folks that ended up in prison. So this is not sex offenders in general or sex offenders in Colorado in general. These are just the folks that earn their way to prison on a lifetime offense. And you see that most of them are in that, you know, research-based, highly criminogenic age range of, you know, basically 20 to 45. Do they ever get out? We often hear they never get out, they never get out. It's a lifetime sentence. That's not true. It's really, really not true. We have the Lifetime Supervision Act enacted in 1998. We had the first sentence in 2000, and then the first release was by 2003. Of course, there's a lag there where they weren't really being released in 2000, 2001, 2002 because they have to successfully progress in treatment, and that takes some time. Certainly, treatment time can change, but the Department of Corrections, their sex offender treatment and management program does track the average time it takes somebody to get through treatment, depending on their risk and needs level and their responsibility or responsivity to treatment. You know, that can be anywhere from, you know, 8 months to 2 years. Certainly not everyone sails through it smoothly, and so it makes sense that people were not getting released in those early years as quickly. But you can see they are getting released. So out of that 2,700, by 2018, last July, certainly this number has increased, but 974 of those folks had at least been initially released from prison. Many of those folks you see in those gray boxes had gone back and been re-released. So some people have been revoked off parole and released more than once. The thing that I think that is important and why I put this really messy gray bar down here is so that you could look at it as a spectrum. One thing I think that people miss is they look at this and they say, well, a third of them have gotten out, but 2/3 of them haven't. Well, a couple of points about that. First, no one has been there longer than 19 years. No one. Because it was only enacted in 2000. So no one has spent their life in prison on a Colorado sex offense under the indeterminate sentencing scheme. Also, some of these folks aren't designed to get out. Some of these folks, the judge has looked at this case, has heard from the victim or survivor, may have heard testimony about the offense or offenses, and has given that bottom number, even though it's an indeterminate sentence, theoretically, has given that bottom number is 300 years. It's 300 to life, or 200 to life, or 50 to life, or 60 to life, and based on the age of that offender, the judge is intending for this to be a life sentence, but can't directly impose a life sentence because we don't have direct life sentences for any sex offenses. So you have to realize that some of these folks are not designed to get out. They're never going to get out, and that's the decision of the court, and that's how it was supposed to be. So when you take those offenders and you sort of lock them off the end, and then you look at who's gotten out, it's a pretty good number. It's a third to a half of folks have gotten out, and some of them in a very short amount of time.
Can I ask a question
Certainly.
about sex offender parole?
Sure.
Some folks are familiar with the acronym SOISP, so for sex offender intensively supervised probation.
Right.
So, which if you fail, for lack of a better term, you might then after 2 or 3 times, 3 on average, wind up in prison, right?
Right.
But, tell us a little bit about, is there an equivalent strict sex offender sentencing once you're on parole, or is parole kind of the same for everyone?
It's not kind of the same for everyone. They can have special terms and conditions, certainly a parole similar to probation. They do have an intensive supervised parole scheme and a special department that manages those and is familiar with sex offenders, and then certainly you can be revoked off parole. So it's similar, but the policies are different. Probation is run by the Colorado Judicial Department. And certainly parole is run by the Department of Corrections. And so there's different policies, different levels of decision-making that are required before someone is revoked under those 2 scenarios, if that makes sense. So they don't always have that decision-making in the same way in terms of what their policies are around when they're going to revoke someone. But as you can see here, not only do people get out, not only is it not true that they never get out, but a fair chunk of them get out and then get out again. And so I think we found one guy in the data who'd gotten out 3 or 4 times off parole after repeatedly violating it. And I'm glad that you asked that, Kirsten, because when you're thinking about this population again and you're remembering that many of them began in the community, you're talking about folks who have repeatedly demonstrated high-risk behavior in the community such that they got revoked off probation, then put into prison, who we've invested the time, resources, and intervention of treatment into. They've successfully progressed to treatment, they've gotten out, and then they're failing in the community again and coming back. And so I say that just to place into context that, Colorado really has a deep, committed investment to giving every opportunity and every resource that we have in order to give these folks opportunities multiple times to demonstrate that they can be safe in the community. And that they can engage in appropriate behavior and engage in treatment. And sometimes that's not possible. So that's what the scheme is for. You see 974 folks, more than that now since this is mid-June last year, have done this and they've gotten out and they've not come back. Some folks were intended by the judges to never get out, and then there's a chunk of folks in the middle who maybe they'll accomplish it one day, maybe they won't, but there it is. And the other thing that I think is really important to note that is a benefit of the indeterminate prison scheme or the indeterminate sentencing scheme that is distinct from a determinate, meaning a specific number scheme, is incentive. If I give someone a 3-year determinate offense or 10-year, it doesn't matter, sentence, and the judge just says, okay, 10 years, they are going to have a mandatory release date, meaning no matter what they do, no matter whether they participate in treatment, they are going to be released on a date certain that they're aware of. And so they might be provided the opportunity to participate in treatment that might reduce their risk to reoffend, but they may decide to do what we call kill their number instead. They may say, you know what, I know with those parole eligibility dates, I know with my mandatory release date, I can be out by such and such a day and I don't have to do this. And sometimes they choose to do that. With an indeterminate scheme, there is an incentive to participate in treatment and accountability that would reduce your risk to reoffend if you're released into the community. And so that's an important factor. I remember a case in Jeffco that I had where, for a variety of reasons, including victim input, an offender against a child was given the opportunity to remain in the community, to be initially sentenced to probation. And then he got into treatment on probation and he realized, man, this is really hard work. And he actually came back to court and self-revoked because he realized how short his actual effective prison sentence would be, and he'd rather do that. So if we were to return to an entirely determinate scheme, that would be an important factor that we'd have to consider. How are we going to incentivize this population to do the hard work of treatment? So when did these guys get out? What did the actual sentence mean? So if you look at this left column, so these are the folks. We couldn't track every one of them because the data for a couple decades ago is not great. But of the 974 that were released, we could tag 868. So it's a fairly large representative sample. And we looked at their minimum sentences. That's the first column on the left. The second column is the number of offenders who received that sentence. The third column is the shortest time they served before initial release, then the average time, then the longest time. There's a couple of things to note here. One of the most interesting data points I found was sometimes I think members of the community or victims think, okay, if a judge has an opportunity to pick a bottom number between 2 and 6, for example, so it's 2 to life or 6 to life, the judge is going to base that bottom number based on some sort of severity of the offender or the case or what have you to life. And that's not really true. What we find is that most judges are putting their faith in the indeterminate sentencing scheme to say you'll be in there for however long it takes for you to earn your way through sincere participation in treatment to be out until we've determined you're as safe as we can make you, which we know we can't completely prevent reoffense, and they're giving that bottom range. So on 2 to 6 to life, they're giving 2 to life. And so most of the offenders are sitting there in that earlier range. And so they're being given the very earliest opportunity to do the work and get out. At any rate, you can see here that most folks served pretty short sentences. Even someone on a 30 to life was out in 14 years. If you look at those 2 to lives, which of course can include sex assault on a child, many types of sexual assault on an adult, the average time served by early release was 6.7 years. That is not a very significant amount of time especially when you compare it to other crimes that aren't sex offenses. When you compare it to robbery or you compare it to, physical assault or other types of things, these folks, if they're motivated, if they participate in treatment, are often out sooner. So this sort of comes as a shock to most people because they see, for example, plea bargains to very longer determinate ranges. So the case comes in, it's sex assault on a child, and the prosecutor says, okay, I'll take the potential lifetime sentence off the table, but I'll plead you to 30 years. Most of the time, I think a victim and a prosecutor think that that's a bargain, when in reality, if that offender is someone for whom we think, based on what we know about them, they're going to be willing and able to engage in treatment, they might be out much sooner. But that's the carrot and the stick of indeterminate sentencing, right? Because the other side of that is if they refuse to participate in treatment or they can't ever be intervened and treated, then they can be there for the rest of their lives. So those are the time periods. So oftentimes we often hear these folks are never getting treatment. They're waiting forever and ever. They're there past their parole eligibility date. They're never getting treatment. So remember that parole eligibility date. Your 2 to life doesn't really mean 2 to life. It really means 11 months to life or maybe straight into community corrections. Though we wanted to see who's in prison past their parole eligibility date, and is that because of treatment? Or is it just because they're obstinate? They're not admitting their conduct, they don't want to participate in treatment, or for some other factor. And also remember, the parole eligibility date doesn't mean that's when you're supposed to be out. That's just your opportunity to make your case to the parole board. So the fact that you're past your parole eligibility date could simply just mean you have more work to do, you didn't have an adequate parole plan, there were other factors that played into community safety, you hadn't been adequately punished for your crime. There are many other factors besides treatment that affect both sentencing and parole. So we found 716 folks that were on indeterminate sentences in prison past their parole eligibility date. Now 38 of those they had been released and they were back. So to me, that's not a treatment issue. We've treated them. They just, sort of screwed up their opportunity in the community. 200 had been treated, meaning they'd met their criteria, but they weren't paroled by the parole board, and that's a parole board decision. Certainly victim input matters, certainly other factors, so that's also not a treatment issue. 272 of them were on the waiting list or the global referral list past their parole eligibility date, but they had flunked out of treatment in DOC before. So again, that's not a treatment capacity issue. We've given them treatment or an opportunity at treatment, and they weren't successful, and now they're back at the end of the line, which is probably an appropriate way to manage folks. So that left 244 who had met criteria to begin treatment, but they did not have a prior opportunity at treatment in the Department of Corrections. So the question for us was, well, is this really a capacity issue? And we took a look. So of those 244, there were 82 that just flat out, their number had come up and they had said, okay, we have a treatment space for you. And they were like, I don't care, I'm not discussing my offense, I'm not admitting my offense. And they just got put back at the end of the line. If you are denying your offense or refusing treatment, you're still on the waiting list. They're still going to ask you next time your number comes up. But we can't force folks to participate in treatment, right? So, that's not a resource issue. A couple were medically ineligible or had some other factor that prevented their ability to participate in treatment. Several had a pending case, another prison assault, whether it was a prison sexual assault or just another case, trailing case that had not been resolved. The department does not begin treatment in those circumstances until those cases are resolved, which makes sense. So that left 137. So now we're down to 137. Those 137 folks included, of course, you probably already heard me beat this dead horse, but people who had already had multiple prior opportunities of treatment in the community. To me, that is not a resource issue. We have given you every opportunity in the community on your probation or COMCOR sentence. You have repeatedly shown that you can't be in the community. Now we're at the highest level of containment and you're waiting to try treatment again, even though you've not been able to successfully do that multiple times. That's not a resource issue. Those 137 also include offenders with lower end minimum numbers. So if you remember, on 2 to life, if you're eligible to 11, you can't possibly get through treatment. And if you remember that chart with how many folks were at the 2 to life level, you're automatically going to, even if the Department of Corrections offered you treatment on day one, as many treatment spaces as possible, you are going to be past your parole eligibility date just because of how early those are before we can actually effectively treat you. And then it also included offenders who were in denial, I'm not going to admit my offense over and over until just prior to their latest parole eligibility date, and now they're ready and they're waiting their turn. So I broke that out just to say this sort of like mythos around this person who is, perhaps this young man who's 19 and has sex with his 13-year-old girlfriend and rapes a child in that manner, or who, whatever the least offensive fact pattern the defense bar can throw at us, who gets sent straight to prison in Colorado and then sits on a waiting list far past his parole eligibility date because of treatment capacity, even though he's ready, willing, and able to engage, and even though he's not in denial and absolutely admitting his offense. That's not a real thing. At least it's not in any significant number. If we call that Bob the Unicorn, it is very difficult to find Bob the Unicorn in Colorado. That's just not a real thing. So even when we looked at those 137, remember they've had prior opportunities in the community, a lot of them. Remember they've had early parole eligibility dates. They couldn't possibly have completed treatment. All of those other factors that apply to them. This was who that population still included. 16 who had a prior known sex conviction. Of course, you remember our funnel, so that doesn't mean only 16 had repeat offenses or prior offenses, just 16 that have made it through that funnel twice. 48 of them had had a prior opportunity at treatment. 30 had multiple known child victims. 1 had 9 known child victims. 1 offender had been convicted of offending on a child at the age of 4, treated, went through the whole process, and then offended on that child at 14. 101 of them had not served the full minimum sentence imposed by the judge. So even if you allow for the argument that they're waiting past their parole eligibility date, they had still not served that bottom number. So if the bottom number was 4 to life, they still hadn't reached 4. So they're not waiting that long. And then 129, all but 8, have become parole eligible in the past 2 years, which again means they're not sitting for these enormously long lengths of time. So that's what we know about the population that has made it to prison. Certainly, I think that there is some thoughtfulness around the indeterminate prison scheme or indeterminate probation scheme that Colorado has set up. One thing, for example, that we know is that someone's risk to reoffend in the community isn't really tied necessarily to their offense. You can have, certainly that's a factor, but you can have someone who's committing indecent exposure, for example, which would be a misdemeanor to children, and then is a really high risk to commit other types of sexual crimes, and sort of vice versa. And the indeterminate scheme right now is really based around offense. It doesn't account for the type of trauma impact and type of conduct that we know that these offenders pursue. So certainly there are ways that we can improve it, but when you are looking at how a state might build a system that accounts both for those who can be responsive to treatment and supervision and those that will never be, the indeterminate prison sentencing scheme is pretty much designed to do just that. And it's fairly unique in the country. So that's Colorado's indeterminate sentencing scheme. I am happy to answer any questions that you might have, but that's all I have for you, Kirsten.
I'm sure there are questions. We'll give folks a moment to type.
Okay.
What about, this is one I hear all the time, even my afternoon drive time show home
Sure.
with DJs were talking about it the other day, that if you are, maybe drunk and can't get to a public restroom in time or not, whatever the case may be, that public urination is a sex offense and lands you on the sex offender registration list. Can you address that?
Absolutely. Public urination is absolutely not a sex offense. In Colorado, we have what we call mental states, which is, a mens rea, which is a sort of a fancy term for what the offender's intent, or what they have to be not doing something accidentally, they have to be doing things knowingly. And so every sex crime in Colorado requires us to prove that the offender knew what they were doing, and sometimes even that they had a specific intent in doing it. And so for indecent exposure, for example, we have to prove beyond a reasonable doubt to a jury that the person is exposing themselves for the purpose of sexual arousal, gratification, or abuse. So certainly if a person is able to say, well, I'm exposing myself incidentally because I'm urinating, we would not be able to prove that they were exposing themselves for sexual purposes. And so that would not be a sex offense in Colorado.
Okay. Here's a
Sure. So we have a question. You said that the parole board is run by the Department of Corrections. Who runs probation? So the parole board, certainly these are all set up by statute. The treatment program and the referrals to the parole board are run by the Department of Corrections. Probation is run by the Colorado Judicial Department. So probation officers are employees of the Colorado Judicial Department, which includes judges, of course, in Colorado, but about 3,600 other employees of various types, court clerks, but one of those departments is probation. So that's who does that, and they are constrained somewhat by statute in terms of which crimes require sex offender intensive supervised probation, those types of issues.
Do you want to address any of those?
Yeah, and we had an email that had some questions. So one of those questions was, can the Department of Corrections release a perpetrator with an indeterminate sentence who has not completed treatment in the Department of Corrections? This is a really, really important question, especially for those of us, COVA included, who will be participating in policy discussions down at the Capitol. Right now, the Department of Corrections is supposed to only refer offenders to parole on an indeterminate sentence where they meet those criteria. So they've successfully progressed in treatment and they have been found not to be a significant risk to reoffend in the community. Now, what does progressed in treatment mean? That's subject to interpretation. Right now, there is a memo by former Attorney General Kaufman that interprets that phrase to be pretty strict, frankly, to mean that they have to have substantially completed treatment. Certainly, a different Attorney General Weiser, or a future Attorney General could take a different interpretation of what that means. So that's an important place where we are all, various stakeholders are paying close attention to what the Department of Corrections considers successful progress. But that is only to refer someone to parole. Community corrections is considered a prison environment, even though you and I and everyone in the community knows it's a halfway house in the community, that community corrections is in the community. That's why it's named community corrections. The executive director can refer someone to community corrections, and there are no criteria around that at all. So one of the arguments that you will hear is, well, there's more treatment available in the community, so we're going to refer these offenders to local community corrections boards for placement in the community. Of course, the data that we've just gone over shows there's plenty of treatment available in the Department of Corrections under the lifetime for indeterminate folks. It's not always true for the determinate population, but it is true for the indeterminate population. And so, you know, personally, I'm opposed to referring folks to community corrections where they have not met the criteria, to placing them in a community environment when they haven't successfully progressed in treatment and when they haven't demonstrated that their risk to reoffend has been sufficiently reduced. But that's not a requirement of the law. So theoretically, yes, they can go to the community, to a halfway house type environment prior to participating in treatment. Is it possible for the perpetrator to remain in prison indefinitely, or can new laws change the decision by which they are incarcerated? Certainly under the indeterminate scheme as it's currently enacted, pardon me, as it's currently in statute, you can be there forever. Some people will be there forever. Can a new law change that? Absolutely. And there have been several efforts over the years to eliminate this. And if you consider it from an offender advocate or a defense attorney perspective who's ethically obligated to advocate for the best position of their client, and of course what their clients want is to be out from under supervision, they don't like the idea much that an offender can be there forever if they can't get the treatment. So the legislature could certainly have second look sentencing or otherwise reduce or eliminate the indeterminate scheme at all, or otherwise reduce or eliminate the sentences that were imposed previously.
So, okay, I think that answered it, but I'm thinking of, you know, our once in a while super high profile serial rapists who have, I'm thinking of two, one of them I think has a 300-year sentence, the other one had, you know, in the 200 somethings, and I mean, these are people with multiple victims, very violent attacks.
Right.
It's then, you know, hypothetically legislation could be passed which then releases that person or lowers their sentence, which is, you know, these are the folks you said that the judge intended them to be there for life because they're sentenced to 257 years or something. So if I'm one of those people's victims, I need to, I mean, this hypothetically could impact if something like that were to come along.
Hypothetically, I mean, I don't know that it would go that far. But if you think about it in the juvenile context, so we used to have options for juveniles to be sentenced to life without parole.
Okay.
And then the Supreme Court said, no, that's not constitutional. And we had to enact a legislative scheme that essentially provided for rehearing, resentencing for those juveniles. So it's certainly possible that you could do something like that. I think that the legislation that's been attempted so far has been to either eliminate the Lifetime Supervision Act entirely, so that we would go back to a determinate prison scheme or sentencing scheme, or to change the way it's imposed in some way. So for example, one of the legislative proposals this year, certainly that we oppose, but that has been proposed, is to eliminate the requirement that they do treatment at all before being paroled. Certainly I think that that's not in the interest of victim or survivor or community safety, but we won't get into it in the weeds about that. But certainly any sentencing grid or scheme can be changed, and the legislature could provide an opportunity for resentencing for those folks. The next one was, I already answered that. Can a perpetrator with an indeterminate sentence be released to a halfway house? Yes, absolutely. Does the victim have the right to speak at that hearing? It's not a hearing. So the executive director of the Department of Corrections refers someone to community corrections, and then it's up to local community corrections boards, which are made up of multiple stakeholders. So a district attorney, a defense attorney, there are victim advocates on those boards, but they each operate according to their own policies and rules. So there's no formal that I'm aware of, like VRA right, for example, to speak at a community corrections board. Am I wrong about that? I don't think there is. I'd have to think about that, but I don't think that there is. What are the, I already answered that. Already answered that. Okay, so I got through that email. And the next question looks like it's, how did I come into this career? What academic route did you take? So I'm an attorney. So I have a law degree. And I came into this career by starting the way most prosecutors in Colorado do, in county court. Which can include some types of sex assault, unlawful sexual contact, indecent exposure, but really is a general docket. And then was assigned to the Special Victims Unit, which in Jefferson County is crimes against children. So it can include sex offenses against children, but can also include other types of abuse against children or homicide of children. And then the district attorneys, the 22 of them, collectively voted a couple of years ago to create a position at the state level that just focused on sexual assault. And so I am the first person in that position, and we're still making it up as we go along. So that's the route. All right. Any other questions?
I'll look into the Concord. I don't have my own statute on me.
Yeah.
Any other? We'll kind of just double check the chat box here for a minute and see if anyone else has questions. And if you joined us a little late or got pulled away and came back, just a reminder that the webinar will be available on COVA's YouTube channel, which is COVA 789, within the next few days, and you'll be able to catch it again later or share it with colleagues.
Sure. Well, thank you so much for having me. Certainly you can reach me through COVA, through Kirsten. I'm happy to answer any other questions that might occur to you after this. I think, though, that,
That's all.
Okay. I think that the biggest thing to note as you're talking to victims and survivors, or as you're watching legislation down at the Capitol, is certainly there are improvements that can be made to the scheme, but whatever sentencing scheme that we come up with has to account for both those folks whose risk to reoffend can be reduced and those folks that can never be in the community safely. And when you're trying to strike that balance, it's a very individualized determination based upon every case, every victim's input, every set of facts and circumstances, and every offender, which is going to be really unique. So we have to have a sentencing scheme that accounts for that. In the olden days, pre-1998, we just had these sort of extraordinary risk range long sentences. It didn't matter how hard you worked at treatment. It didn't matter if you refused treatment. It didn't matter how many victims you were, or how many offenses, or the egregious nature of your offense. There was a set mandatory release date, and that's when that person would return. Certainly that's not as individualized and evidence-based as what we have now. And so, the flexibility of the system is designed to protect the community as much as we possibly can. With that said, thank you for having me, Kirsten, and thank you to everyone for attending.
Everyone have a great afternoon, and then get something great for lunch.